the Ghanaian got his application granted based on the submission, the reconsideration that was put forward. Good night to everybody. Welcome to my live. All things legal. If you have any immigration question, any UK immigration question, feel free to put it into the chat, or you can send me a message. Follow my page and send me a message. Okay. Tonight, I am going to talk to you about a success story in relation to an application for naturalization in the UK. Okay. Initially, it was refused, but then in the end, it was victorious. So that's the topic tonight. It's about a success story. Okay. So this is a success story I'm going to share tonight. So there is the person was from Ghana. So it's a Ghanaian. Yes, that's how you pronounce it. And they made an application for British citizenship. Okay. So they came into the UK around 2008. So which means they were in the UK for at least, up to today, it's about 16 years. All right. So they're in the UK for about 16 years. They came in since 2008 and they made an application for British citizenship. Okay. Now that was refused on the basis of that the client did not have good character. So if you did not know, your application for citizenship can be refused if the Home Office is satisfied that you do not have good character. And normally good character, the Home Office will look at your past 10 years history in the UK. All right. So the Home Office will look at your past 10 years history in the UK to determine whether you have good character, whether you're a good standing citizen. Well, not a citizen, but a resident. Okay. Now, if you're an overstayer, that can be a reason why you have not fulfilled having good character. Also, one of the main thing is that if you have convictions, that's one of the main obstacle that can cause your application to be refused, not having good character because of your conviction. All right. If you are a follower on my page, you would have heard me say over and over that the Home Office are human beings just like you and I, and they would have before them guidance. Okay, so they have guidance before them, just like how I have my notes on my paper. They would have guidance before them, and whenever they're looking at an application, they would follow the guidance before them in determining the application, whether it is granted or refused. Okay, so it's more like a tick box exercise. However, there are what you call exceptional compelling reasons or circumstances why an application should be granted. So despite having the guidance there, does the person satisfy A, B, C? The Home Office also have to look at exceptional circumstances, insurmountable obstacles. Okay, meaning significant circumstances. So this person applied for British citizenship and it was refused on the basis that he did not have good character. Okay, so the person is in the UK since 2008. That's a long time. And what happened is that they had a conviction. They had a conviction on their record. And because they had that conviction on their record, the Home Office, the immigration officer, found that conviction on their record within the last 10 years. And for that sole reason, they rejected the application. With the conviction, he was sentenced to 12 months. So originally, with the conviction, he was sentenced to 12 months in prison. Okay. However, he appealed the conviction. So the conviction was appealed and the sentence was reduced. So it was reduced to 8 months, 7 months rather than 12 months. So follow me. Okay, the conviction was reduced from 12 months sentence to 7 months sentence. All right, so on appeal, he got his conviction reduced. Okay, so yes, he was convicted. Queen Advocate said that's ground for refusal, 12 months. Yes, but let's get to the part where it's very interesting now, Queen Advocate. And Emily, if you're listening, let's get to the part where it's very interesting now. So, of course, by law and the Home Office guidance and rules, 12 months is enough to refuse the application for naturalization. Okay, but the key factor here is that his sentence was reduced from 12 months to 8 months on appeal. Now, what should Home Office take into consideration? What should the immigration officer take into consideration? The 12-month sentence or the 8-month sentence? Let me see what Queen Advocate or Emily or anyone else who's following the conversation is going to say. What should the Home Office take into consideration? The 12-month sentence or the 8-month sentence? Emily says 8 months. Okay. Triniton said 8 months. Yeah, everybody's saying 8 months. Queen Advocate say 8 months. Thank you. Right. I'm not sure if it's the act that is after 2023, but there was a policy that came in after 2023 that stated that anyone who gets a conviction and gets a sentence for 12 months or more can be refused, okay, on that grounds, despite if they had good character before. They can be refused on the grounds of not having good character. Okay, so the immigration officer looked and considered the 12-month sentence rather than the 8 months reduced sentence, and that's where the mistake happened, or that's where the refusal was wrong. So you receive your decision for your client and it says that, his application for naturalization is refused because they had a conviction and they had a sentence for 12 months and it's after 2023. So the immigration officer did not take into consideration the reduced sentence on appeal. That should have been taken into consideration. So as the client, solicitor, immigration lawyer, what do you do next? What do you do next? Because remember that they went to appeal, it was reduced to 8 months, then they applied for their naturalization and that was refused on the grounds of not having good character. And as a solicitor, if that comes back to you and you know the law, you know the rules. So what you have to do now is that as a solicitor, as a lawyer, you now have to make submission asking the Home Office to reconsider their decision. And by making that reconsidering application, you have to put forward your submission, which is directing the Home Office as to the law, as to the rules, and as to the facts of the case. Okay? So that's what had to be done. We had to direct the Home Office as to what needs to be done. This is the rule. The client had a reduced sentence. Yes, for them to look at it again, HK. As Queen Advocate was saying, you're putting forward a reconsideration application for them to have a second look at your application, have a second look at the details, at the information that was submitted. Okay, if you have a good lawyer, they know what to do, especially if the lawyer knows that they are in the right and that this was an error on the part of the immigration, on the part of Home Office for refusing the application. Sorry, okay? So in this instance, the Home Office got it wrong because they applied the rules based on the 12-month sentence. But in fact, he got 8-month sentence. Yes, waste court time, I'm telling you. So sometimes you have to have a smart and astute solicitor to know why are we going to court with this. Let's do a reconsideration application back to the Home Office. Avoid going to the court. Okay, right. And in doing so, what had to be done is that we have to, what's the word, we have to weigh, we have to balance the mitigating factors against that one time he was convicted. So during the lifetime, never had any interaction with the police, never had any bad character apart from that one encounter, good standing person in society, law abiding person. There's nothing that could have contributed, no other record, no other no other conviction. Everything was good on his slate. So this helped with the submission to show the Home Office that, listen, the mitigating factors, this person is a really good gentleman. He's never got into any encounter with the law or anything like that, and you got the determination wrong on this one. So in your submission, you put forward all of that evidence to show that he's been a good standing citizen. Okay, and then it's for the Home Office now to have a look at the submission on the balance of probabilities. Okay, so they must take into account all the information that we submit to them on behalf of our client. They must take into consideration that all the mitigating factors, okay, all the contributions that he would have made to society. The Home Office must now reconsider their decision of not granting the naturalization to the client. So, and also you look at the length of time that they've lived in the UK as well. That contributes as well. You look at their age as well, the date of the conviction, and other circumstances. Okay, so never bankrupt. That's part of good character. The age, your contributions to society, all of this adds towards good character and adds towards your application as well. Okay, and the Home Office came back and granted the application. So that's the success story there. The Ghanaian got his application granted based on the submission, the reconsideration that was put forward. So I'm saying this to say that if you have a really good solicitor, they will know what to do in circumstances like this. Rather than wasting clients, wasting your money, wasting the court's time, as Queen Advocates say, wasting your time as well, and wasting the solicitor's time. You have to know what you're doing. Send the application, send the submission back to the Home Office for reconsideration. And nothing is wrong with guiding the Home Office as to where you think they made an error and what they could have done in assessing the client's application. The Home Office will look at your submission, and once they know that they made an error, they will acknowledge it and grant the application, and it's ended right there. Okay, so that's the success story today on naturalization and good character. So you have to be careful when it comes to good character. You don't want to have any convictions. Emily says, well done. Thank you. You have to be very careful with good character. It's one of the easiest way for Home Office to refuse your application. Okay.